Good afternoon. Attorney Protective would like to welcome you to today's webinar, Claim Reframe, Best Practices to Avoid a Legal Malpractice Claim. Please reference your materials for information about today's speakers, Irwin Kramer and Kate Gould. And with that, I would like to introduce your first speaker. Kate?
Thanks, Erin, and thanks so much for joining us for today's webinar. Before we jump into the presentation, I want to take a quick look at the agenda. First, Irwin and I will walk you through some legal malpractice statistics. And we include this information because it's helpful to dive into the what and why lawyers are being sued today. We believe that if you understand the factors, you'll be in a much better position to avoid the types of claims driving the malpractice cases, and also in a better position to understand how to protect your firm when it comes to best practices and legal malpractice coverage. So we'll start by covering what practice areas are generating the most claims, what are the most frequently alleged malpractice errors, and how much it typically costs to defend a legal malpractice claim. We'll then turn to nuclear verdict trends, specifically what is driving the nuclear verdict trend takeover right now and its effect on the insurance industry. We'll then switch gears a bit and talk about insurance limits and how a claims-made policy works, and the potential consequences of having inadequate coverage. And then we'll discuss the ethical implications of being underinsured as well. We'll then wrap it up with a discussion of the value of robust intake procedures, including how to spot the problem client, and leave you with some best practice tips for effective engagement letters and fee agreements. Now, you'll hear a lot from Irwin on this portion of the discussion, and I think you'll agree it's really important because the best defense to avoiding a malpractice claim is really having a good offense. And we want to help you make sure you're doing everything right on the front end to be proactive and hopefully put yourself in a position that you never have a claim. So finally, we will wrap up with our final thoughts and Q&A at the end as always. All right, so moving into the next slide. So in the next few slides, this is going to be somewhat of a statistic-heavy portion of the program. As you'll see, we are going to present data collected by Ames and Goff through their surveys. And if you're not familiar with Ames and Goff, they're a specialty insurance broker that conducts a lawyer's professional liability claim survey about every other year. The survey examines key trends driving law firm malpractice exposures and claims by polling lawyers' professional liability insurance companies. So in general, you'll see this is what they found on the screen. Both legal malpractice claim frequency and severity are up. Over the past few years, we were actually seeing legal malpractice claims frequency had stabilized a bit, but unfortunately, we're now seeing the frequency climb back up. Rising claim severity has been climbing steadily and continues to be a major challenge for law firms. And when we ask, why is this? Well, 19 of the 13 insurers surveyed pointed to social inflation as contributing to the risk of large claim payouts. So digging into this a bit more, 4 of those insurers cited growing awards from sympathetic juries as the main driver of social inflation. And we'll talk about the effects of social inflation in more detail in just a bit when we talk about nuclear verdicts. We also note that 2 insurers cited the fear of trial leading to larger settlements, and 3 insurers saw social inflation being driven primarily by an aggressive plaintiff's bar, third-party litigation funding, or corporate clients shifting the blame for bad decisions to their lawyers. Irwin, has that been what you've seen in your practice and experience?
Well, in my experience, and of course I don't get into statistics because candidly, Kate, the one statistic that matters to me is the number one, and that's my client. Mm-hmm. And when it comes to a lawyer at the receiving end of a malpractice action or a disciplinary action for that matter, I do them both, you don't care about percentages anymore. You care about the fact that you have a 100% chance you have gotten a malpractice claim. And so I can't tell you that in my experience, the claims are on the rise. That's something that you can best judge, and that the insurance brokers who study this can best judge. What I can say is lawyers have never been popular. Social inflation, at least when it comes to lawyers, has always seemed high to me. We are somewhere a cut above, or maybe not, depending on your experience in buying cars, above used car salespeople. And the fact of the matter is that you don't want to be at the receiving end of it, whether you're right or wrong, because the aggravation alone is just not worth the price of admission. The key here, and one thing that I'll harp on, is that the best way, of course, to avoid a malpractice claim occurs long before anybody's tempers are flaring, before anyone is threatening, before any claim is made. So my experience is very anecdotal. It deals with the individual lawyer who is at the receiving end of an action. And on that score, the lawyers come in all shapes and sizes, but I can tell you that people will often assume when I'm at cocktail parties and they ask what you do and who you represent, and I say I represent lawyers in malpractice and disciplinary matters, and the initial thought is, you represent the bad lawyers. And that's just not true. I represent outstanding lawyers. I represent lawyers who I consider to be better lawyers than I am. These are not claims that come to bad lawyers. This is not a question of intellect or legal aptitude or knowing the law. Much of what we're talking about today deals with process and a failure of process and the right systems in place lead to more claims than a lawyer who fails to properly interpret the rule against perpetuities. That's been my experience.
Yeah, the dreaded rule against perpetuities. We're reaching back to law school on that one.
Well,
thanks.
fortunately,
really
I made a promise to God that if He let me pass the bar, I would never practice property law. And for the most part, I will say I've been able to avoid the rule against perpetuities my entire career. But I did have to go back on my promise about property law because I've done a fair amount of real estate litigation over the years. So the bottom line, though, is that it's just not about that high-level legal mistake. It usually is not that. Has that been your experience? I mean, have you found that when you look at the malpractice claims that you have within your company, is it because somebody just didn't interpret the law in a perfect way and some nuance or very, very unique aspect of esoteric law? Or is it, I blew limitations because I didn't have the right tickler system or something of that kind? What are you finding?
Right. Yeah, I would agree it'd be the latter. Quite frequently it is more of the, kind of mechanical aspects, the procedure, just not having those best practices, I think, in risk management to avoid such claims. So before we move on, I want to touch on a couple more things on this slide, a couple more highlights that support the statistics. And that's the fact that there's more lawyers today than ever in history. So, quick math, more lawyers equals more claims. So there's actually, you might be surprised to know, nearly 1.5 million lawyers in the United States alone, with about 200,000 more lawyers every year since 2008. So again, just more lawyers, more claims. We're also seeing more and more lawyers dabble outside their comfort zone. And quite frankly, this is a really great way to be sued. Insurance costs are also rising, which means there is a larger target and arguably that bigger pocket I think that claimants see. And finally, the last bullet on your slide, litigation funding, is listed here too. And just a little background for those who may not be familiar with it. In most instances, a third party pays a litigant's attorney's fees in exchange for an interest in the outcome of the lawsuit. And litigation funders assess the strength of litigation as an investment. In this way, litigation funding can provide access to justice for litigants that otherwise could not afford it, or can help minimize the risk for litigants by sharing costs or risk with third party. And although this is somewhat controversial, courts are allowing the use of third-party financing agreements, and the ABA has reviewed the issue and concluded it doesn't involve any per se ethical violations. So regardless of your, personal feelings on it, it is also contributing to the rise in claims. So let's look at the hard numbers on the next slide. For years, the Ames and Goff survey has found the same three practice areas to generate the largest number of claims, and that being trust and estates, business transactions, and corporate and securities. And you'll note that this is actually the 2024 survey. We're awaiting the publication of the 2026 survey in July. We should have it soon. But I would expect those numbers to be similar. And a question we do get is, why is trust and estates always at the top of the list? And you may have run into this, Irwin, but as you all know, baby boomers are starting to transfer their wealth, and people are upset with what they're getting or not getting. And I think the demand for trust and estates is going to continue to grow, probably exceed the supply of those services. And I also think the fact that when you represent someone and it's a great client and they say, hey, I need a will too, or can you set up a trust for me? You're anxious to do it and eager to do it to keep the business. But that's a dangerous game to play if it is not in your bailiwick, because these cases can take on so many different complexities, and what may seem like a straightforward, cut and dry, form can get really nasty. Do you have any comments to add about that, Irwin?
Well, I think that's true. In fact, it's almost like every lawyer feels they can do a will. Just like every client thinks they can get a will out of a book or go on LegalZoom or something of that kind. And the fact is that when you dabble in anything, you're at greater risk of a malpractice claim, because a little bit of knowledge is a dangerous thing. And I think you hit the nail on the head. When it comes to trust and estates, you're typically dealing with, in many cases, particularly those that would attract malpractice claims, large estates. So the money is certainly there. You're often dealing with warring. When there's more money, there are also more family feuds, right? And so you're dealing with disgruntled family members that perhaps their share was zero or a lot less than they believe they were entitled to. And who do they blame? Well, you can't blame dear old dead dad. Dad is no longer, you can't reach, you can conduct a seance if you'd like, but litigation is for the living. And who's living and closest to dear old dead dad? Dear old dead dad's lawyer. Mm-hmm. So that tends to create this perfect storm of problems for the trust and estates lawyer, particularly because many of the trust and estates lawyers that are sued for trust and estates malpractice aren't really estates and trust lawyers. That's the problem. That's the crux of a problem that I see in many areas of law. That is, I don't generally do this, but all they needed was a simple will. Well, a simple will is very simple if your knowledge is very rudimentary. A lawyer who actually specializes in the area is going to understand that actually a simple will is not going to create a simple result. What it might create is a malpractice claim.
Yeah, 100%. And I think what I'll take from that is litigation is for the living. I like that.
Litigation is for the living, and if you want to live a long and happy life, you try to avoid it, which is the whole reason we're doing this.
That's right. That's right. You will see on this slide before we move on to that insurance defense and plaintiff's personal injury work also made the list. We're seeing a continued growth in claims activity here. So if you practice in these areas, definitely be on guard.
I'm kind of surprised.
On the next slide,
it's funny.
Go ahead,
I'm kind of surprised the family lawyers aren't higher on the list because, boy, they're dealing with nasty, nasty stuff. And you've got complaints out the wazoo when it comes to the disciplinary side. So I was kind of surprised, but maybe it's because there's so much non-monetary relief that a malpractice claim isn't necessarily worth it. Maybe I'm just speculating.
Yeah, that's a good point. That's interesting. Yeah, I wonder if we'll see any difference in the forthcoming survey. So on our next slide, we're going to look at the most frequently alleged malpractice errors. And conflicts of interest remains the single largest cause of legal malpractice claims, with 9 of the insurers polled in the 2024 survey ranking it as the first or second most common error. The next was the Scrivener or clerical errors, which ranked first or second by 4 of the insurers. And these statistics are particularly troubling because conflicts can be very difficult and expensive to defend. We actually do a webinar on conflicts alone every year because there's so many scenarios in which conflicts that arise that I think that some practitioners just aren't aware of. And it's surprising, quite frankly, how many lawyers bury their head in the sand and play ostrich when it comes to conflicts, simply ignoring those potential problems. Others maybe assume that they'll remember all their past and current clients and can anticipate those conflicts. And both of these approaches are dangerous. It's important, to your point earlier, Irwin, that you have those checks and balances in place, that you adopt and use conflict checking systems so you can identify those quickly. This might just be, software you can run with your case management and time and billing software, making it easy to check for those problems. You want to have a consistent procedure for checking conflicts in your office. And before I turn it over to you, I just want to make a mention, too, that when defending these conflicts claims, what we see on the carrier side is that juries don't like when lawyers breach their duty of loyalty to the clients, which is really what the underlying issue is in a conflicts case. And that can mean large verdicts. And in some jurisdictions, and we're speaking to lawyers around the country, it may be true in your state that punitive damages can be awarded in a legal malpractice action based on conflicts, meaning a very costly claim.
Well, clients will forgive a lot of mistakes. What they don't forgive is perceived disloyalty. And that's a crux of the problem when it comes to conflicts of interest. And of course, another is, and I teach professional responsibility at 3 different law schools throughout the year. And we spend more time on conflicts of interest because, candidly, it is the advanced calculus of legal ethics. It is really complicated stuff. And frankly, although clearly we should all have computerized practice management systems that allow us to check conflicts at the push of a button, it takes more than the push of a button to truly assess conflicts. You've got former clients, you've got present clients. We'll talk later about prospective clients, people who don't even retain you in the end, who you don't earn a dime from, are somehow, based on conflicts of interest rules, considered your client for those purposes. So it is definitely a landmine when it comes to legal malpractice claims.
Yeah, absolutely. Definitely requires the human touch. I've got your last chart here on the next slide. We were going to talk about the cost of defending lawyers continuing to rise.
Oh, wow. You know what, Kate? I'm not charging enough money to the insurance companies that are hiring. I love the top statistic. I want to be one of those 2 in 2023 that charge $550 or greater. Wow. Hey.
Well, there you go. You learned something today.
Well, is this something that Attorney Protective pays? I mean, I might want to talk with you about future business. You know, that sounds pretty good to me. I guess you're gonna look at it as a negative. I kind of look at it as, oh, that's pretty good.
I guess it does depend on your perspective.
Yeah, it does.
Well, at the end of the day, mistakes are more expensive year after year, and the survey attributed rising claim costs to factors, including higher legal defense costs due to social inflation, aggressive tactics by plaintiffs' counsel, and the increasing complexity of cases, and especially involving corporate transactions, tax, and immigration. And in terms of the actual cost, 23% of the carriers polled indicated the average cost to defend a claim exceeded $500,000, and 38% said the average cost was between $100,000 and $500,000. So we don't share these numbers to scare you, but it's just really helpful to look at the data and understand the claim trends, so we can better understand how to reduce risk in our practices and make sure we're covered if we find ourselves being sued. All right, the next slide. And I've seen a couple questions come up about what is social inflation. We're going to get into that now. So we're going to turn to our discussion on nuclear verdict trends. And if you aren't familiar with this term, it's exactly what it sounds like. It's a runaway jury verdict that, quite frankly, blows away your expectations and costs. And carriers have closely studied the significant uptick and also the consistencies with these runaway verdicts. And many point to what is known as social inflation. So we keep throwing around this term. What does it mean? It's characterized by the factors we'll discuss today that increase insurers' claims costs above normal economic inflation. So there's a couple statistics there on your screen. I won't read those, but you'll note that, and you may know this if you're in these states, but among the most populous states, Texas, California, New York, Florida, those deliver half of the nuclear verdicts in America. And you also see the numbers in the product liability cases are just staggering. So on the next slide, we're going to look at the root cause of nuclear verdicts. And these are the 3 main factors that drive social inflation. And social inflation is what increases liability claims costs. The most significant effects are observed in the commercial liability markets, with the commercial auto and products liability segments hit the hardest. And the Insurance Information Institute collaborated with the Casualty Actuarial Society to measure the excess losses that can't be explained by regular increases in economic inflation. And the analysis attributed $20.7 billion in commercial auto losses from 2010 to 2019 to loss development factors unrelated to general inflation. So this is about 14% of the total $148 billion in claims paid during that time. So let's look at the first factor that's listed there as societal shifts against corporations. We all know juror bias against corporate defendants and serious personal injury and wrongful death lawsuits is hardly anything new. I'm not telling you anything you don't know. I always think of those John Grisham books turned movies when I think about these juries. And it's not unusual, and it's typically a trial theme for a plaintiff's attorney to compare their sympathetic injured client against what they'll try to show to be a greedy corporation. And this tactic is still frequently being used. And actually, the research is showing that jurors are still sympathetic toward those plaintiffs, and so the plaintiff's attorneys, classic stories are resonating with those jurors' personal biases, increasing the chances of nuclear verdicts. And when you think about it, we see billion-dollar Powerball jackpots, crazy numbers thrown out there. That we have like a lower ability, I guess, to wrap our mind around those numbers. So when you put that in terms of a jury, jurors are just ill-prepared, quite frankly, to determine the damage awards at trials. And they just don't understand the magnitude of money that the plaintiff's attorney is requesting. And they just become desensitized and don't hesitate to issue that outrageous jury award. I don't know if you have any comments about that factor, Irwin.
Well, one thing I have noticed is that insurance carriers in general, particularly on the personal injury side, liability carriers, tend to be very, shall I say, somewhat timid when it comes to what they'll take to trial. I may find that, in my view, a case is perfectly defensible, but the pressure to settle has been much greater in recent years than when I started practicing law close to 40 years ago. And it's probably a reflection of the fact that there are more of these perceived runaway verdicts. I find that frustrating sometimes as a trial lawyer doing insurance defense work, because candidly, if you feel a case is defensible, you'd like to take it down, the whole 9 yards and get a defense verdict at trial. But corporately, I think it does become harder for the carriers to want to take the distance. Now, when it comes to malpractice liability, we as lawyers are concerned about more than just dollars and cents. Clearly, we are concerned about dollars and cents. A nuclear verdict is probably not something we insure for. We're probably all underinsured against the nuclear verdict. But at the same time, it's a reputational concern for us. So I understand that carriers are in a difficult position, and lawyers who are at the receiving end of these actions have to also be concerned that, the best thing to do would be to help prevent these claims in the first place, because when you're at the receiving end of one, there's going to be a fair amount of inertia in the system to get that thing settled.
Absolutely. Yeah. And the next factor on this list, and I'll just quickly touch on it since we discussed it at the outset of the presentation, is that third-party litigation funding. And I'll just mention here that these litigation funding agreements can negatively impact the settlement process. They increase the cost of settlements because plaintiffs are usually unwilling to agree to a settlement that puts little to no money in their pocket after legal fees, costs, and repaying the litigation funder. So that's another kind of trickle-down effect of their involvement.
Here's a question.
The final factor.
Oh, I'm sorry, please. You're about to address that. Yeah.
Oh, yeah. Did you want to talk about the psychological tactics?
What is anchoring in reptile theory? That's an interesting. I've heard of them, and how has that impacted things?
Yeah. So these are psychological tactics used to manipulate juries to return these inflated damage awards. And the reptile theory actually, it originates from a book which I guess called jurors to focus on society as a whole and not the specific case. So the authors in that book theorized that plaintiffs' attorneys use reptilian tactic phrases such as safety rules or personal safety protecting the community. And that's what actually triggers the reptilian part of the brain to overcome the cognitive part of the brain. So they tried to link an argument to a juror's sense of personal or community safety. And they kind of draw on the juror's emotion in that way. So that's focusing them more on the damages, the larger, I guess, potential to the harm to the community rather than the individual plaintiff. And anchoring, to answer your question, is where the plaintiff's attorney requests just an outrageously high damages award to arouse the jury's sense of, what is actually fair compensation. And so they throw that number out there, and then when the jury relies on it, that's known as the anchor, that number. Then they engage in what's known as anchoring bias, where that's kind of the starting point for their damage award. So they just are kind of easily, I guess, persuaded and, quite frankly, anchored to this arbitrary number, even if it's like completely irrelevant to the current situation. All right, let's take a quick look at how we can fight social inflation. Of course, it impacts more than just insurance carriers and large corporations. Insurance carriers react to these high costs by passing along those costs to small businesses and individuals. So it certainly has a trickle-down effect in terms of how much you're paying personally. All right, the next slide. We're going to switch gears a bit to talk about insurance. And I know this message isn't surprising coming from a legal malpractice carrier, but hopefully you all have insurance. Unlike car insurance, surprisingly, only a couple jurisdictions actually require lawyers to maintain malpractice coverage. Just Oregon and Idaho are the states that directly mandate it. There's other states that require lawyers to disclose their insurance status. So you might want to check your jurisdiction as far as that goes. We strongly recommend you carry it. And again, I know that might sound a bit self-serving, but, it not only protects you, but also your client. We'd also recommend, if you do have a policy, to please read it. I know it might be long, but it's important to make sure you understand your coverage and direct questions to your carrier or broker to ensure you have appropriate coverage, even in terms of your limits. Important to, I guess, look at those numbers every time you renew your policy. And you'll see on this slide here, and I won't, read these items, but these are the typically, 6 parts you're going to see on a malpractice policy, kind of like a homeowner's policy. So no real surprises here. We'll move on to the next slide. So these are some things to know about a malpractice policy. Malpractice policies are called claims made and reported policies, and they don't operate the same way as a homeowner's or auto policy. So, for example, if you were in a car accident a year and a half ago and got sued, the policy during that occurrence a year and a half ago applies. That's when the accident happened. But for an occurrence policy, you only need the policy in place when the accident actually occurred. Malpractice policies don't work in the same way. And that's because the client may not know about mistakes or damages for years. So in a malpractice policy, the policy that applies is the one in place at the time the claim is made and reported. And that's why it's so important to tell your carrier right away about a claim. So let's look a bit here about what is covered. And that is damages and claims expenses for claims based on the rendering or failure to render legal services. So a lot of kind of legalese insurance language there. What are legal services? You'll see how it's defined here on the slide. And it's important to note that if a claim is asserted against the insured listed on the policy, most policies place a duty to defend and duty to indemnify on the carrier as long as there's no applicable exclusion under the policy. And remember that these are separate duties. As far as a duty to defend, I would argue that the defense provided under a policy is even more valuable than the indemnity of a loss, as any time an attorney is sued for malpractice, there will be defense costs incurred, but not necessarily a loss payment. Some claims are meritless and can be disposed of by summary disposition, while others are defensible. But defending those claims is often very expensive due to the need for expert testimony regarding the standard of care by an attorney. We'll go to the next slide. So let's take a look at what is not covered. And you'll see we have claims that you should have known about and never reported to your carrier, acts before the retroactive date. The retro date or prior acts date is the date after which an event must occur to be eligible for coverage under the policy. And you'll find that this date is stated in the deck page of the policy and is essentially the date the policy begins providing coverage. So note that claims triggered before the date are not covered. And that's why it's so important to have continuous coverage. You don't want to have those periods of non-coverage or gaps in coverage. You don't want to jeopardize any coverage that might be available to you in the event of a claim. So a couple more things on this list. You'll see the return of fees are not covered or intentional acts for obvious reasons. Next slide. We'll briefly touch on who is covered. And you'll see the list there. So you're going to have the named insured, employees, while at the firm, yes, but not for legal services they perform at the new firm. You can read the list here on the slide.
One thing I don't want to talk.
Yeah, please.
Yeah, one thing I'd like to weigh in on in terms of insurance coverage. It's a funny thing. On the disciplinary side, I'll get plenty of calls from lawyers who do not have coverage, which I can't get my head around that, candidly. I wouldn't get behind the wheel of a car without having automobile liability insurance. Of course, that's required in all states. But to practice law without it, I think, is just as dangerous. And there are a couple reasons why I think you need coverage that we don't often talk about. And that is, there's more than just the claims that you're addressing on the slide. A lot of times, most carriers have a special provision of coverage for responding to disciplinary complaints, for example, where you can get reimbursed for up to a certain limit for certain expenses in relation to a response to disciplinary complaints or defending yourself in disciplinary proceedings. That alone can be worth a lot of money to you in return for premiums. A lot of times I'll see criminal defense lawyers who are low on the scale of malpractice liability, but they're pretty high on the scale of getting grievances. And so their coverage, if they have it, helps to pay my fee in defending them in connection with disciplinary matters. Now, obviously, different carriers have different policies, and you have to check those bells and whistles. But there's that advantage that most lawyers don't even know about. So I'll ask them, do you have professional liability coverage? And they'll say, well, it's not a malpractice claim. And I'll explain to them, yes, but you probably have coverage for some of what you're calling me about, namely a disciplinary problem. The second reason is you would like to have an intermediary, somebody between you and your client, if indeed there is a potential malpractice claim, you don't want to have to negotiate that yourself directly with the client. Maybe the client hasn't gotten a lawyer yet. You'd rather have someone in the claims department of your insurance carrier dealing with that issue, because candidly, that gives you a layer of insulation between you and the client so that you don't get into more trouble in connection with those communications. So that's extremely important. There are intangible benefits, is what I'm saying, both tangible and intangible benefits to having that coverage. And it's, I think, very critical to make sure that we're all not only insured, but properly insured against the risks that we are presented with in connection with our practice areas.
Absolutely. Yeah, your points are well taken. And just so we leave enough time, I want to reserve enough time to get into some more of the practical applications of our webinar. Take a look at some of these aspects of the claims made policy. We won't discuss them in detail, but rather let's move on to how much coverage you might need. You'll see these questions on the slide. There's a number of factors that should be considered when determining how much coverage to obtain. You might also think, too, about whether you refer cases to other attorneys, because that also presents some risk. It wouldn't be unusual if you're referring cases to other attorneys and an issue arises that you will see both the referring attorney and the referred attorney being named in the litigation. And you might also request a copy of their deck page upon the referral. And then finally, the next slide, I just want to highlight some information that AttPro provides. This is a resource called Legal Malpractice 101, which explains a lot of the terms we discussed today or are listed on your slide. So you may want to check that out and understand you're going to have significant benefits, not just the coverage, but the intangibles like Irwin mentioned of having legal malpractice insurance. So now we're actually going to turn to some ethical implications in the event you are underinsured.
Well, certainly. And let me begin by saying that although we're looking at the rule on competence, the problems that we're discussing are not strictly ones of competence. They are not legal competence issues. But competence and Rule 1.1 goes much further than just knowing the law. It involves technical and technological competence as well. It is competence in running your law firm, to me, because candidly, disorganization, the lack of systems put in place to help prevent errors from occurring, to my mind, that is as much a part of the competence that we need to bring to the table for our clients as anything else. And the good news is that most legal malpractice claims are entirely preventable, that the malpractice risks we face are often quite controllable. It is less about intelligence than it is about process. And so I think that's something that we need to bear in mind. Technological competence. I think it would be malpractice, candidly, to try to practice law without good computer systems. There are practice management systems out there, and there are many of them, and we all know they exist, but we don't all use them. And some of the lawyers that I know have them, but don't use them effectively. Have a tickler system. There's no reason to rely on memory. There is no reason, no matter how long you've been practicing law, to write things down by hand on a calendar. I mean, I'm sorry, but that just doesn't work in 2026. Document, document, document. Every phone call. There should be a note on every single phone call. Now, that's a chore, we might say. I mean, I've got to grab a legal pad every time I make a call or get a call. No, the answer is you don't grab a legal pad. You click a mouse button. You click an icon. You type away on your computer as you're having the conversation. It keeps everything nice and neat, well organized. You know who you spoke with. You know when you spoke with them. You know how long you spoke with them for. You have all of that information. Your emails will also be organized within that system. Email, phone notes, things of this kind, make it very easy to document exactly what goes on. It is the lack of documentation. It is the lawyer who calls me and says, yeah, I told the client all about the risks associated with this case, all about the downsides. Oh, really? Well, do you have anything in writing on that? Well, no, but we discussed it at length. Well, you and I both know if it's not in writing, it never really happened, did it? Because if it's your word against an unsophisticated client's word, who is the jury or judge going to believe? The reality is you're the professional. You're the person that is supposed to be documenting this information. And if you don't, that becomes a problem. Now, I know many of us are quite concerned about artificial intelligence. How is that going to impact the practice of law? It's impacting it right now. It is wonderful. I love ChatGPT, and I love it because, candidly, when I do my legal research on it, it finds cases I can't find anywhere else. Of course, it's hallucinating many of those cases, and that's a problem. Obviously, I say that somewhat in jest in the fact that there are many attorneys, we know, we've seen the headlines, that have used ChatGPT for their legal research, not checking whether those cases that they're citing in a brief are real or not. Now, candidly, that's not a new problem. That's called being lazy. That's called being careless. Whether you're careless in the age of technology or artificial intelligence or not, that's not something that is within the standard of care that lawyers have had to adhere to since time immemorial. But I think there's going to be a bigger ethical question down the road, and that is, will it be ethical? Will it be competent of us to practice law without using artificial intelligence? Because candidly, artificial intelligence used the right way can not only be a great time saver and labor saver, but I think it's going to help avoid a lot of malpractice liability. The bottom line is, don't avoid it because lawyers like to say they're Luddites and they're not up on technology and they're not going to use this out of pride. No, there's no pride involved here. If something can save me some labor, if something can proofread my documents better and faster, I'm damn side going to use it. But know what it's about. That doesn't mean staying away from technology. That might just ensure that you are incompetent. It's a question of using it and knowing how it's to be used. Communications with your client. Again, practice management systems make that quite easy. But it's in technology. Technology today, we have instant messaging. We have email. Clients expect answers right away. If you sent an email and it takes more than an hour to get a response, my goodness, I emailed them over an hour ago. What's the problem here? Well, in the old days, it would take years. Well, years. It would take days to get a response. We use snail mail. Things ran at the pace of snails. Now they're instantaneous. So we have a greater obligation not to get back fast as lightning. We can't do that all the time. We're busy. We don't have just one client. We have 100 clients, and they all have demands. It's all about managing expectations. That's really the problem. When the client's expectations exceed the lawyer's reality, you're going to have complaints. When you have complaints, you're going to have potential malpractice liability. Do we have to disclose that we're underinsured? I see here the title is Ethical Implications of Being Underinsured. Do we have to disclose to a client what our policy limits are? Well, not in my state or any of the jurisdictions I practice in, and probably not in most. I don't know, and I can't tell everybody on this webinar that I am any expert in all 50 state laws, because I, have enough trouble mastering two. But the fact of the matter is that the client is entitled to information that would enable them to participate meaningfully in their own representation. I think that might mean, at least if it's ever interpreted this way, to tell them that you're not really insured for this or inadequately insured. The bottom line is, if you are, you don't have to worry about that disclosure or whether someone is going to say that you needed to make that disclosure in the end. The value of robust intake procedures. Sometimes you can communicate too much with clients. And herein lies the problem of the accidental client. There are individuals who are going to be calling you and asking you advice before they pay you any money and want to get a thumbnail sketch. Just give me a ballpark of what I'm looking at. Or just, I'm not going to hold you to it, but just tell me what you think. And if you tell them what you want to be helpful, you want to help the person that's calling you on the phone. You want to give them a little bit of advice. My advice is that no good deed goes unpunished. Be stingy with your advice. It's okay to be helpful. It's okay to be courteous. But remember, you may not be retained by a given client. You may not expect that you have any duty to them. It isn't your expectations that control legally. It's the client's expectations. If somebody thinks that you're giving them legal advice and they act in reliance on it to their detriment, guess what? You never got retained and you weren't paid a dime, but they're your client for purposes of malpractice liability. There are prospective client conflicts. We talked a little bit about conflicts of interest. One conflict we don't often talk about is a conflict with the client that never even retains you. Rule 1.18, take a look at it one of these days. When you're flipping through and have nothing better to do than look at the rules of professional conduct, take a look at Rule 1.18. It says that if somebody contacts you, doesn't even retain you, that you can't use the information you receive if it's going to result in substantial hardship to them or substantially to their detriment. What that means is that somebody who spills their guts to you on that web form that you have where they're to describe all the information about their legal problem, may be giving you so much information, not only are you not retained by them, but you won't be able to represent somebody else who is willing to pay you. Be very careful about the communication flow. That is critically important. Have disclaimers on your website, but don't rely on them, because guess what? Most prospective clients aren't even reading that fine print, for God's sake. It might even say, do not, you might even have a click wrap agreement that says, I know that I'm not, you're not representing me unless I retain and all that. But you know what? You get the information anyway. That's a problem. There's a famous case of a client who actually left a lengthy voicemail for the lawyer and talked about all her extramarital affairs. Turns around, he winds up representing the husband in a divorce action. Now he's got information that he didn't even solicit. Now, I don't think that's necessarily a conflict, but it creates these kinds of problems. Problem clients. Learn how to spot the problem client. Candidly, some of it requires a crystal ball because everybody presents well on day one. Just like that job applicant that you've just interviewed and looks like the answer to all of your prayers, you don't really know what you have until you're on the job. And the same is true about a lot of clients. But there are some problem clients that I like to call the dreamers, the victims, the vengeful, the cheaters, the evaders. Look, there are no perfect clients. But if the client is dreaming and has expectations you don't believe you can rein in, that's a problem waiting to happen. The victim who complains about all the lawyers that they've dealt with that are terrible. Oh my God. And, this is part of social inflation that Kate's been talking to us about. They don't like lawyers, or they've had bad experiences. Now, you might even agree that the prior lawyer on that case did not do a very good job, and you can do better, and you might even be right. But you know what else you are? You're next, because now they're your problem, and you are the next person on their list. If they've been wrong before, the chances are they're more likely to blame you if something goes wrong again. Be careful of the victim, the vengeful, somebody that wants to take it out on their ex-spouse and they need a pit bull. I don't do any domestic litigation, by the way. I've tried to avoid that. But whenever somebody comes in and says, I want you, Mr. Kramer, because I hear you're a pit bull, I don't live in a kennel. I appreciate that that's supposed to be a compliment, but I'm not a dog who is trying to fight tooth and nail to get even with somebody else. If that's what they want to do, you know what? They could turn their vengeance on me next time. The cheater who's trying to weasel out of a contract. Now, they might have legal grounds to do it, but guess what? You've also got a contract with that person. So now are they going to cheat you out of your fee? The evader who can't answer a question directly. Look, there are no perfect clients, and you're not going to be able to spot them all, but you at least need to see the red flags and to at least identify traits that you can deal with down the road in managing expectations.
So, Irwin, if you do get that client in your office that you do want to sign up, just since we're running short on time here, do you have any specific tips about engagement letters or fee agreements, or what would you say about that, just in general?
First of all, you hear a lot about limited scope representation, right? You hear about, there's this new rule on limited scope. Every piece of representation you do ought to be limited scope. You need an engagement letter that is going to say exactly what it is you're going to do and what it is you're not going to do. I'm not going to handle that appeal for you. Because client expectations are controlling when it comes to malpractice actions. And you got to manage those expectations. And the best thing to do is to do it in writing through a proper engagement letter, proper retainer agreements that say what you're going to do, what you're not going to do. Also, if you spot a client whose expectations you don't think you can rein in, well, then don't take them. I tried to do that one time in quoting a ridiculously high retainer amount, and I had that check on my chair that same afternoon, and the client became my biggest nightmare. Don't let your guard down and say, well, I wouldn't normally represent this person, but this is such a big case. Guess what? If it's a big case and we let our guard down, it's a big malpractice case somewhere down the road. That becomes a bit of a problem too. Define who you represent, who you don't represent, what you're going to do, what you're not going to do. What are the client's responsibilities? All of those things are critically, critically important. And effective engagement letters are customized. You may have a template on your computer system, but you want to modify it to meet the situation at hand. If you see a problem, you think this case is going to be a challenge, spell it out in writing. Because otherwise, you're going to have a client who says, my lawyer said it was a slam dunk. And now I find there's no law. Well, that's not the nature of the conversation. Clients often hear what they want to hear. They're not lying, but they aren't professionals when it comes to legal services, and you need to understand that. So make sure, beyond all the engagement letter tips, that you customize it for the specific situation. Very critical. Here is an excellent template that you're provided by Attorney Protective, but a template can only do so much. You've got to do the rest, and you ought to do it every time for every situation. Stay within your lane when it comes to practice. Evaluate problem clients. Utilize a robust intake process That's a computerized process as well. And do rely on those effective engagement letters because there is probably no better risk management device than that.
Great. Well, thank you both so much for these wonderful tips. And at this time, we would like to welcome you to ask questions. With that, we have a couple of great questions coming in. The first one is notifying your insurance broker of a potential malpractice claim sufficient notice to the carrier?
I can take that one, Irwin, and I'll give you the classic law school answer of it depends. It quite honestly depends on your policy. So another reason you need to read your policy closely, I would certainly reach out to your broker and probably call the carrier as well as just that belt and suspenders approach. There's no reason to jeopardize your coverage or have an issue with notice because you didn't make that second phone call.
Great. Thanks, Kate. Another question that came in is, what is the best way to define the scope of the engagement for purposes of the engagement letter?
Well, I guess it depends upon the nature of the case. The best way to define it is to look at the contours of the case that you're handling and also understand what the ramifications are. I mean, for example, if I'm a personal injury lawyer, I'm going to say that I'm retained to represent you in connection with a contingency matter through trial. If we need to appeal in order to reverse an adverse decision, that would need to be negotiated separately, and we would need to sign a separate retainer agreement. If I fail to do that, then guess what? My simple retainer agreement that says I'll represent you in recovering for your injuries is so open-ended that I'll have to appeal for free. Now, obviously, if I won the case below and I want to preserve the verdict, I'm incentivized, of course, to do that, and that will be indeed a part of the representation. But the opposite, I don't necessarily want to be true. If I've got a loser of a case, do I want to spend more time on it? If I don't, then I better, in that scenario, limit the scope. So again, you can't answer that question totally in the abstract. It's an excellent question, by the way. I'm glad somebody put that in. But you can't answer all of these questions in the abstract. The key is customization. The key is, what is this matter presenting in terms of issues, and how do I best define the parameters of what I'm going to do and what I'm not going to do?
I would absolutely agree. And to your point you made earlier, you might also just state what you're not going to do. Sometimes that's even more important than what you are agreeing to handle for the client.
Yeah, and here's the other thing. And here's the other thing. We know the legal business. We know what the mores are. We know what lawyers typically do in a given situation. But each of our clients may not have any experience with that. And so it's their expectations that we need to manage. That's the key.
But with that, we'll ask one more question to our presenters today, and that is, should I disclose to my client whether I have malpractice insurance?
I think Irwin touched upon this a little bit during the presentation. But I would just follow up and say it may depend. You may be obligated under the laws of your jurisdiction, so I would definitely check that. And it may be worth doing in your kind of attorney obligation section of your fee agreement as what you're committing to do for the client. I think it shows courtesy and care for the client. It's protection for you and them both. Would you have anything to add, Irwin?
Yeah, I would say if you would be embarrassed at the answer, fix the answer. Get yourself adequate coverage. It is going to pay dividends for you. It'll give you peace of mind. And therefore, regardless of what your state might say about the obligation, you're covered regardless. And I think that's the most important thing to take away.
That's a great answer. Well, at this point, we are out of time for further questions. That concludes today's event. To thank all of you for joining us for today's webinar. And I would also like to thank our speakers, Irwin and Kate. Thank you so much. This was a great presentation, and I hope everyone has a wonderful day. Thanks.